Good afternoon and welcome to the Public Safety and Government Operations Committee meeting. In attendance today, I've got myself, Mark Conway, representing the 4th District, Councilman Cohen representing the 1st District, Councilwoman Porter representing the 10th District, and Councilwoman Ramos representing the 14th District. And visiting us today is Councilman Dorsey representing the 3rd District, and Councilman Glover of the committee representing the 13th District. Representing the Office of the President, I've got Preston Lewis, and representing the Mayor's Office, I've got Tyler Chanella. So today we're going to do Bill 24-0491, footway repairs, citations, and billing for the purpose of altering the notice and appeal timelines for certain footway improvements, gradings, pavings, repavings, or repairs, accepting an assessment from bearing interest under certain circumstances, making conforming changes, and generally relating to the citation and billing process for footways repairs. This bill was introduced on February 12th, 2024, and was sponsored by Councilman Dorsey, and I'll hand it over to the sponsor to explain the bill.
Thank you, Mr. Chair. Thank you, committee members and everybody who's here. This is a very boring bill. It's just a very straightforward improvement to administrative process. But it came from months and months and months of fairly regular meeting between me and representatives from the Law Department, the Zoning Board, and the Department of Transportation to address kind of soup to nuts the issue of sidewalk violation notices and everything that's required in order for the Department of Transportation to afford people due process when citing people for violations of the footway conditions, and particularly when people contest those and bring them before the zoning board. So it was a really strong collaborative process. I think it was a learning process for everybody in how this process goes. And one of the things that came up, I always try to take constituent cases that come my way. If it happens once, it's just a thing that happened. But if it happens twice, 3, 4 times, you start to go, what is the underlying thing in the way that the city is operating that I'm continuously having this thing come my way? And a thing that came my way a couple of times was where constituents who had just purchased their house were suddenly being sent a bill for a footway repair that they knew nothing about. And it turned out that the footway repair had happened a year earlier when somebody else previously owned the house, and it had just taken that long a time for the bill to be sent. And I said, what is going on that it's taking us a year to send out the bill? And the issue is that there's this antiquated provision in the city code that says that even after the Department of Transportation has given you notice that there is a footway violation and given you an opportunity to contest whether or not the footway violation exists and whether it needs to be repaired or whether it's as extensive as DOT might have said, you get through the whole process, and DOT, you have this back and forth with DOT, and you determine the sidewalk needs to be fixed. The sidewalk gets fixed. Even once the work is done, the Department of Transportation is not allowed to just send you a bill for the work that they've done that you knew they were going to do and send you a bill for. They have to put a notice in 2 daily newspapers of the footway's repair before they're allowed to then send you a notice that you are going to get a bill, which then allows you to contest whether or not you owe that amount of money a second time. And then a third notice comes to you from the Department of Finance, which is the actual bill for the work. And because it's so costly to do these newspaper notifications, the department doesn't just, your sidewalk gets fixed and then they put a newspaper notification about your sidewalk, or your block with 10 other houses get fixed and they put a notice in the newspaper of those 10 houses. No, they wait for huge contracts to be done because it's much more cost effective for us to do these newspaper listings when we've exhausted whole contracts. And so, it can often take 6 months, 9 months, a year for a contractor to work through all of the funds in their contract to do that much sidewalk work throughout the city. And so it could be a year between the time when the work is done, if you are at the beginning of that contractor's contract, and when the work is finished. And then the newspaper listing happens, and then you get the notice that there's going to be a bill, and then only after a month later does the finance department then have the right to actually send you the bill. All this delay means that there's, that the constituents who I heard from are not an anomaly, that there are going to be plenty of cases where somebody gets a bill for something that they had nothing to do with or knew nothing about a year prior when somebody else owned their house. And this also means that we can't turn around that money fast enough to do as much sidewalk work as I think that we should be able to do and could be able to do, right? Because sidewalk repair work that is, the financial responsibility of the adjacent property owners, it's essentially a revolving fund, right? So we spend money that we've got in the bank here to make that work happen, and then when we recoup that money, we're able to re-spend that money. After we bill for it, we're able to re-spend that money on more sidewalk work to get done. If we can recoup that money faster, then we can do more sidewalk work in a given time, and so that's what this bill is about. It does away with that newspaper listing requirement and consolidates the two, what comes after that newspaper listing, the notice from DOT that you're going to get a bill and the finance department actually sending you a bill. It consolidates that into one. It still affords you all of the same opportunity to contest the work or the necessity for the work, again, still at the front end, so you will still get the violation notice that says that there is a problem with the sidewalk and how much it needs to be fixed and how much, an estimate of how much it's going to cost to get it done. And then after the work is done, you will still get this other notice of here's how much is owed to you, but again, you can contest it still. So people still have the right to be heard by the Department of Transportation or by the zoning board to appeal the decision of the Department of Transportation or just appeal in general the assessment of how much is due. So we're not changing anybody's ability to intervene on their own behalf or stand up for themselves in any way. We're just streamlining the process. So I think it's kind of boring, but it's going to improve the way we operate for folks.
I think it's very exciting, Councilman. It's thrilling. I think, finding inefficiencies in city processes is, I think, one of the things that people get really frustrated about. So I appreciate you bringing the bill forward and look forward to diving into it. So we're going to jump into agency reports. First, we have the Law Department.
Thank you, Mr. Chair. Michelle Toth on behalf of the Law Department. We approved the bill for form and legal sufficiency, assuming that the Law Department's recommended amendment is adopted.
Thank you. And we have that. Yes. Okay. We'll talk about that amendment later on. Next up, we have the Department of Transportation.
Hello, my name is Marley Cardona-Ramos. I'm here with the Department of Transportation. We're here in support of Bill 24-0491. I also have Mohammed Kondakar and Michael Donovan, our subject matter experts, with us in case you have any questions. Thank you.
Thank you. Department of Public Works.
Good afternoon, Mr. Chairman and committee members. Marcia Collins, representing Department of Public Works. We had deferred to DOT as this particular issue is referencing the billing issue that the councilman who is sponsoring the bill so thoroughly analyzed and explained to us, and we'd be happy to answer any questions if we can be helpful.
Thank you. BMZA.
Good afternoon, Mr. Chair. Jim Allman on behalf of the BMZA. The BMZA supports this bill.
Thank you. And finally, the Department of Finance.
Good afternoon, Mr. Chair and members of the committee. The Finance Department supports this bill.
Thank you. Any questions from the committee? Seeing no questions. Yeah, let's cover the amendment. Would you like to explain it, or would you like the Law Department?
The amendment from the Law Department pertains to the bill that you receive after the work is done, and how specifically that bill will let you know that you have the right to contest or appeal the bill. As drafted, the bill said you have the right to, for appeal of assessment, a property owner may appeal an assessment. And this amendment just elaborates on that by saying, to the Director of Transportation within 10 days of receipt of notice of assessment from the Director of Finance, or to the Board of Municipal and Zoning Appeals within 30 days of mailing of a notice of assessment in accordance with Section 10.9 of the subtitle. So it just elaborates on this statement that already exists, that you have the right to appeal. It just says how you have the right to appeal, not one, but two different ways.
Thank you. Any questions from the committee about the amendments? Seem pretty straightforward. All right, we're going to open up to public testimony. If you have an intention, I don't see anybody here. I see a bunch of no testimony here. And if there are any folks joining us virtually that wish to testify, use the raise hand button or the raise hand function. We'll acknowledge you. Going once, going twice. All right. Seeing no public testimony, we're going to move forward.
Mr. Chair, just really quickly for the record, because I didn't say it earlier, the administration also supports this legislation. We appreciate the councilman for, as you mentioned earlier.
State your name for the record.
Tyler Schnella, Mayor's Office of Government Relations, finding an inefficiency within a process that one of our agencies, specifically DOT, conducts routinely that impacts city residents, and wanted to ensure that the process is such that they can be successful, and that the city of Baltimore can be successful in paving and correcting any damage to sidewalks. And just want to thank the councilman for his diligence and for his partnership. I want to say that the last meeting we had to walk through the changes and to discuss the bill lasted about 2.5 hours. You know, and we stayed the course, and we are now here today again with the piece of legislation that we are proud to stand behind, and just want to flag that for all council members, that that is the way that we prefer legislation to work, right? Is that we come to the table together and work through the process and ensure that we are putting forth legislation that will benefit city residents.
Absolutely. And when you guys have those 2.5-hour meetings, that means this hearing doesn't have to be 2.5 hours.
Right. And we're working on another one with Councilman Cohen. So that's 10+ hours on
There
that
we go.
one.
It might have felt like 2.5.
All right. Any comments, questions before we move to a vote? I'll accept a motion on the amendment. A motion on the amendment. Moved by Ramos, second by Cohen. Conway, yes. Porter? Yes. Cohen? Yes. Burnett is absent. Glover? Yes. Ramos? Yes. And Costello is absent. All right. I'll entertain a motion to move the bill as amended. Moved by Porter, seconded by Ramos. Conway, yes. Porter? Yes. Cohen? Yes. Glover? Yes. Ramos? Yes. All right. This moves on to second reader at the next council meeting. Thank you, Mr. Chair. Thank you, Councilman. There we go. I love it. This hearing is adjourned.